Welcome, everybody. It's a pleasure to be moderating this panel. It is sponsored by the ICC Committee of the American branch of the International Law Association, which I co-chair with my colleague, Professor Megan Fairley. Our panelists are very distinguished, so they hardly need introductions, and I will keep them short. We have Ambassador David Sheffer. He was the first US war crimes ambassador serving under the Clinton administration. He's a clinical professor emeritus and director emeritus at the Center for International Human Rights, Northwestern University Pritzker School of Law. We have Ambassador Clint Williamson, who was the third US war crimes ambassador, serving under the Bush administration and is a professor at American University, Washington College of Law. We have Professor Diane Orentlicher, who was deputy to the fourth US war crimes ambassador, Stephen Rapp, who was also head of the Office of Global Criminal Justice, and she is also a professor at American University, Washington College of Law. And we have Professor Michael Newton, who played a key role in the drafting of the ICC Elements of Crimes, and is a professor of the practice of law and professor of the practice of political science and director of the Vanderbilt in Venice program at Vanderbilt Law School. So thank you to the panelists for being with us here today. So the theme of International Law Weekend is reinvesting in international law. Coming out of a period of time where the last administration put sanctions, namely travel bans and asset freezes, on the ICC prosecutor, Fatou Bensouda, and Fakiso Mochichoku, head of the JCCD of the OGP, and others within the OGP, it does seem an appropriate time for the US to reinvest in the relationship with the ICC. To set the stage, most of the audience will know the US is not a party to the ICC's Rome Statute, and it has had a varying relationship with the court. During the Clinton administration, US delegates attended the Rome negotiations under the leadership of Ambassador Sheffer and helped negotiate the statute, although the US did not sign it at Rome, but the US did sign on the last day it was open for signature. Under the Bush administration, particularly the first term, the US had an antagonistic relationship. First, disavowing the US signature, then implementing Article 98, also known as bilateral immunity agreements, insisting on Security Council resolutions creating peacekeeper immunity for peacekeepers from non-state parties, and Congress passing anti-ICC legislation, some of which remains in place. The relationship was not fully negative. It did improve during the second term of the Bush administration, and the US did permit the referral of the situation in Darfur as well as other measures. Under the Obama administration, particularly under Ambassador Rapp's leadership, the US engaged constructively on a case-by-case basis with the court. I already referred to the hostility of the Trump administration, which is probably the height of US hostility to the court, since sanctions are typically reserved to the likes of drug traffickers and terrorists, not officers of a judicial institution. We are now in the Biden administration with our friend and colleague, Professor Beth von Schaack, nominated to be US War Crimes Ambassador. And congratulations to Beth, if you happen to be listening. So I will now turn to the panelists with a series of questions. And I will just say to the audience, there will be time at the end for Q&A. So if you want to start thinking of questions, you could put them into the Q&A feature. So to the panelists, in terms of charting the path forward, I will direct my first question to David and then to Mike. What should US policy be on the ICC going forward? Should the US return to the Obama administration's approach of constructive engagement on a case-by-case basis? Can the US improve on that? And is the US always bound to change in its relationship with the ICC when different administrations come into office? David.
Thank you so much, Jennifer. And it's a great pleasure and honor to be speaking at International Law Weekend again. It used to be one of my favorite trips to New York City each year, which the last time was 2 years ago. So it's good to be back, at least on screen, with all of you. I just have a couple of very brief points to make to get this started. First, the latest document that everyone should be reading who is interested in this issue is the American Society of International Law's report entitled US Options for Engagement with the ICC. Some of us on the panel today dealt with this report in an advisory capacity. It's authored by Todd Buchwald, formerly of the State Department Office of Global Criminal Justice as ambassador, and by Beth Von Schack, who is now nominated to be the next U.S. ambassador at large for global criminal justice. It's a very lengthy report, and it gets into all of these issues in great depth and fully footnoted. And I just suggest that's the template you should start with if you really want to get into this subject, because some of what I will say will be reflected in that report. But the point that I'm going to make right now is actually not in the report, unless you sort of read between the lines. And that is that we've been here many times before during, at the start of so many different administrations, we take another look at the ICC and what US policy should be about. I wrote a report in 2008 with the start of the Obama administration, and the ASIL did as well at that time. So we've been here before. And I think in terms of kind of labeling where we should go in the future, instead of just sort of replicating constructive engagement, which was the Obama administration's template, led by Ambassadors Stephen Rapp and Diane as his secretary, Diane as his deputy, sorry. What a slip. What I would suggest is that we kind of think of it more as a policy of accommodation and engagement. That's a somewhat more positive, and I would argue constructive, way of looking at the ICC, but I'm going to put a little bit of a spin on it. I think we need to have more of a realpolitik attitude towards the ICC. Namely, how do we start thinking about the International Criminal Court in terms of its advantages for United States foreign policy and military policy? We've sort of gotten into a rut over the last 20 years of constantly thinking about the ICC in a threat environment. In other words, what are the threats? What are the risks of the ICC for the United States? I would turn that thinking around now. I think we're at a stage with the experience of the ICC, and frankly, with the confidence of the United States under the new administration, the mantra, we're back, that we're in a capacity now to see what are the advantages of a more intensified relationship of the United States with the ICC, but from a realpolitik perspective, because there are advantages that can be derived from a relationship with the ICC. And of course, I would argue that ultimately there would be advantages with a status of ratification of the Rome Statute with the ICC. And frankly, we need to list those advantages now. We need to checklist that. We need to know what it is that would be to our advantage if in fact we ratified the Rome Statute, and not constantly look at checklists of what I think our colleague David Bosco would argue is sort of the passive marginalization agenda of the United States with the ICC. So I would just strongly recommend that. And my second very sort of ancillary point, but I do think it's actually quite important. We need to start demonstrating to the rest of the world, not necessarily that we're going to ratify the Rome Statute tomorrow, but rather that we're going to ratify the underlying treaties that really provide strength to international criminal law and to the laws of war that we're, quite frankly, really far behind on. And I list them as the Law of the Sea Convention, Protocol 2 to the Geneva Conventions, the Arms Trade Treaty, the Landmines Treaty, and the Cluster Munitions Treaty. Now, the Pentagon will have some thoughts about all of this. All of us have lived through this. But the point is, these are treaties that are, many of them have stood the test of time. And I think it's time, frankly, that the United States have itself a very constructive attitude about these treaties. So I'll pass it on, Jennifer, to Mike.
Terrific. Thanks, David. Mike.
Well, that's interesting. Great minds think alike. And I want to pick up on David's realpolitik framing, except taken in a slightly different direction. You know, I think we both started from pretty much intellectually the same place. And so I sort of thought of maybe 3 or 4 concrete things that we should do moving forward. And I want to point out, a lot of our participants will know this, some may not. Of course, you have a new prosecutor, a new Assembly of States Parties president, a new president of the court, a new registrar, the independent experts report that's being, debated, and we'll see what the ASP does with that. I think the ICC as an institution is right now in a really, been through the formative phase. We've been a toddler for a while, maybe longer than some people would want. I think we're only now moving towards the period whether this institution matures and grows and assumes its rightful place. And I think everybody who's on this panel at least shares the vision of the ICC as having a very constructive place in the international scope, but also a limited place. It's not the single solution. It's not designed to be that elementary place. It's designed to be the pinnacle of the pyramid. I think we really need to go back to that as a core national priority. And in saying that, 3 specific recommendations just to think about going forward. And by the way, one set of backdrop, remember that 10 of those 15 populated countries of the world are not states parties, which means that over half the world's population is not subject to ICC jurisdiction. This is not a universal jurisdiction court by design. So really what I'm talking about is bringing into fruition the actual design of the statute, which is to work in conjunction with domestic systems, to work effectively, to work impartially, to be apolitical, but to really have a functional role. And I think that's really the challenge that we've seen over the last little bit. So that's kind of the way I thought about what we should do as a United States policy going forward. Sort of 3 specific things. Number 1, I think we need to go back to a clear national statement that the prevention and the amelioration of atrocity crimes, David's phrase, writ large, is a core national security interest. And we need to be very clear about that, not in some wispy, ethereal, general human rights justice kind of a way, but very concrete as a core national security imperative for lots of reasons. And I think moral righteousness can be added to that, a non-legal reason, that it is a core national security imperative. Secondly, I think we need to be very clear that the Dodd Amendment language in the American Servicemen's Protection Act is not some evil, bad thing. It's a necessary tool of US foreign policy, one that gives us an incredible breadth. You used the phrase constructive engagement that began during the second Bush term and then really came into fruition later. And it was a pretty productive period of cooperation, but it was also on a lot of different fronts in a lot of different ways that didn't draw a lot of headlines. But that happened because the interagency and because specific policymakers recognized the power of the Dodd Amendment and used it appropriately. So I guess what I'd say is, if I wanted to summarize that, we have the legal authority, let's use what we have. And in that vein, one footnote would be, I think we need to be very careful. David points to other areas where we need to expand US law and treaty obligations. I think we need to be very careful that we don't undermine our existing prerogatives and our existing statutory authorities. I'm in the school of people who says that some of the reforms to the UCMJ, while they make sense in a lot of other ways, would also detrimentally affect the rights and abilities of commanders to investigate and prosecute war crimes. And I think that's a serious danger that we need to flag, because the prevention of atrocity crimes and the responsibility of commanders as a core national security imperative has to be enabled and sustained and not undermined. And then the third big thing, and we can have a whole panel on this, we all have lots of experience in these just internecine battles. But I really think we have to revisit our interagency organization for how we do this. And part of that, with particular respect for the ICC, is a designated focal point, a designated, the ICC prosecutor, Kareem, should not have to guess who to talk to get results in the US government. It might on one day be the ambassador for global criminal justice. On another day, it might be somebody at the NSC. On another day, it might be a Pentagon official. We need to have a lead agent authorized, but then an interagency set up to support that, from intelligence support to LEVSL reporting and lots of other ways. And I just think we need to be very deliberate about this. It won't happen by accident.
Great, thank you for those thoughts. Diane or Clint, would you like to weigh in briefly on this question? Diane? You'll have to unmute. Yeah.
There, sorry about that. First of all, I want to thank you, Jennifer, for organizing this really important and timely panel. I also want to say that in terms of the challenges ahead, really the best news I've heard in a long time was the nomination of Beth Von Scott to be the next ambassador at large for global criminal justice. She is really about as stellar an appointment as I could imagine. She is also going to need a lot of support, and I know that she has a lot of support. What I want to just add to the comments that have just been made is not a more pessimistic view of the environment, but I think it's important going forward for us to acknowledge that we are in a different environment than we were at the beginning of the Obama administration. There are some amazing opportunities right now, and I want to come back to that in a second and then wrap up in a second. But we are in a challenging environment, and here I'm referring in particular to some investigations that I know we'll likely get into soon, the Afghanistan and Palestine situations. And more so the Palestine situation now. And that is going to affect very profoundly the pressures on the Biden administration. It's not going to be operating in a vacuum as it works toward defining its relationship to the ICC. And it's going to be getting, and already is getting, a lot of pressure from Congress. And so with that in mind, I want to kind of propose that I think it's important for us to be aware not only of the challenges, though I think it is important to be aware of those, but also the opportunity we have for a reset and a fundamental realignment. And I think David Sheffer was getting toward a similar point. And I would like to suggest two kind of broad themes that may be important as we work toward that. One is to consider it a good thing to achieve a measure of overlapping consensus with the International Criminal Court. And by that, I mean, we're not going to agree on everything, but there are so many areas of consensus and agreement where we can make real progress together. And secondly, and the ACIL Task Force report makes this point as well, I wouldn't underestimate the importance of rhetoric. I think Mike talked about the importance of strategic messaging about our commitment to justice, but I also think that's going to be an important point for NGOs as well, as we work through the challenges that the Biden administration is already poised to address. And maybe I'll say more about that later, because I know it's time to move on to some other questions.
Great, thank you, Diane. So my second question, and I'll address this to Mike, particularly focusing in on the Afghanistan investigation. The ICC Prosecutor Karim Khan recently announced the OTP was seeking authorization to resume investigation into the Afghanistan situation, focusing on crimes committed by the Taliban and ISK, Islamic State Khorasan province. So this suggests he is deprioritizing investigation of US nationals, members of the CIA and DOD for war crimes. Primarily, the issue is one of torture, alleged to have been committed in Afghanistan and potentially Rome Statute state parties that house secret prisons. So my question is, first, I kind of guess if you have something like an official hat on, you might greet this news positively, that the US is backing off these investigations. But given really the very limited number of individuals who the US has prosecuted, particularly if you look at members of the CIA, isn't this a situation of uneven application of the rule of law? And doesn't it look hypocritical? And I just know, the ICC recently also backed off the UK investigation into torture. So the US and UK nationals are not getting looked at in terms of their conduct when a lot of other situations are going forward. And I know the US has been very supportive of international justice, but it seems to be more supportive when other nationals are being prosecuted, to put it bluntly. Mike, what is your reaction to all of the above?
Well, thanks for the easy question. Everybody else goes on mute and, goes away. Boy, there's so much to say here, and you threw out a lot. Let me try to disentangle some of it. I think it's a very simplistic view, actually, for somebody who takes exactly what you said, just, from a purely US hat. You take joy that the court appears to be backing off Americans. Number one, I'm not sure you can actually correctly draw that from the actual press release. The actual press release says, I'm going to focus my limited investigative capacity, which everybody knows is too limited, and 52 different directions, probably more. That's just a number I made up. So, I could easily read that. I'm a former prosecutor. I might, I tried lots of cases. I look at that through a prosecutor's hat and I say, all right, looking at the integrity of this case that's already been developed, knowing that 99.9% of the evidence that I actually do have came from official US sources from the plethora of interagency investigations and witness statements, just a mountain of evidence. What more productively can I get for the moment under the present circumstances? Margin, not much. So I look at that as a prosecutor and I say, I want to build a viable case, assuming I want to charge an indirect co-perpetratorship. How in the world am I going to prove an indirect co-perpetratorship? And against who? That's where I would focus as a prosecutor. I also think, given what we're seeing on the ground in Afghanistan right now, I'm looking at the most egregious crimes that I can actually, as a prosecutor, develop and prove beyond a reasonable doubt. You better believe I focus on those crimes. We've talked a lot, and I think we've talked theoretically about the possibilities of deterrence and all of that. And now I look, you can still see I nicked myself shaving, sorry. We've talked about the possibility of deterrence. Well, there's lots of sides to that debate, but if you do want to deter any activities and any more human rights abuses on the ground, you make exactly the same statement to that exact same effect. And you say, yeah, we're going to pour our investigative resources in there. With respect to the technical details, I've got a lot to say on this. I just published a piece that you helped me edit early on SSRN. I think the actual Afghanistan investigation at the PE phase was flawed in some pretty fundamental ways, which I point out on SSRN. But one of the statements that's in the OTP request for investigation, and I'll read it to you because I don't want to misquote it. It says, no national investigations or prosecutions have been conducted or are ongoing. Well, when you look at the mountain of things that were done, and this is one thing that I wish the new administration would do with the consent of DOD, is to release the entire list of official persons who were punished and sanctioned. We did say in public reporting to the ICCPR report and in the Committee Against Torture, we know of about 300, but we also know of about 600 investigations that were opened. At one point, 22 of 23 investigations in Afghanistan had been opened and founded. We did a lot. I think the story big picture is that the American system worked in a halting way, but it worked. It did what was supposed to be done. And to the extent that there are actual prosecutorial gaps, then we address those. One last thing, I think, it's easy for us always to focus on, a particular person that we wanted prosecuted or a particular, I'm a prosecutor. I'm like, I would have charged this, or I would have prosecuted that, or I would have done that. That's our natural tendency. But remember, in human rights law, and in the Rome Statute, to be very clear, the validity of an investigation, the word genuinely, is an obligation of means, not of results. And I think we need to be very clear about the narrative that says, look, we want to have effective investigations. You know, there's the long line of admissibility cases that talks about what that means. It looks like subpoena power. It looks like witness statements. It looked like, you know, documentary evidence that's seized and secured. We've done a huge amount of that. And where there are holes and we can make the system work better, that's the conversation we should be having with the court. But I think more importantly, for our own purposes going forward, for United States national imperative purposes, that's the priority. Because I would expect, and frankly, if I were a US official, I would demand that the court respect our right to use our system and our law to prosecute. That's what the design of the Rome Statute is in the first place. And so I do think Diane's right. It's a difficult time, but I also think we bear the affirmative burden of showing the world against a lot of distrust and misinformation that we have done a lot and that we are doing a lot. And that you know, Taliban activities are a very different matter from at least at the present moment, from anything that happened under our watch. And I think that properly, to go back to the prosecutor's statement, absolutely, if I were the prosecutor, that's where I'd put my focus right now.
Thanks for that. I'll ask if any of the others would like to weigh in on this, but I would just note that Mike talked about prosecuting members of the DOD. And we do know from the Senate Select Committee on Intelligence report that there was a large torture scandal by the CIA of high-value detainees in secret prisons. And I think we either have 1 or 0 case having been pursued. So I'm just noting the ICC case is looking at DOD and CIA. But I don't know if Diane or Clint or David, Clint.
Yeah, and I mean, this is one of the points that I was going to make. I think the argument for complementarity is much stronger where DOD is concerned than as it relates to the intelligence community. The only other point that I wanted to make is, you know, I agree completely with what Mike said, that, you know, we need to be careful about not reading too much into the statement of de-emphasizing potential investigations against US personnel. But to the extent that is going to be the approach going forward, I think it generally will be welcomed in Washington. But I think there's also another view that goes with that, and it's a bit of a double-edged sword. I think for some people who are ICC skeptics, this just confirms some of their misgivings about the court, namely that these types of decisions really rest with the whim of the prosecutor. And where you had a prior prosecutor that seemed very interested in pursuing these cases, now you have another prosecutor that has just made the decision, no, I'm not going to do it. And they're not going to go into the type of analysis that Mike just described, and particularly looking at it from the perspective of a prosecutor and why this might make sense. But rather, the lesson they may take away from it is that, as I said, it just, you know, reaffirms what they believed all along, that there are no institutional safeguards there, or insufficient institutional safeguards there, and rather that this is personality driven. And if you have the right person in the job, that's great for the US. If you don't, it's not. So I'm not sure that the impact of this is entirely positive where the US is concerned. Interesting.
David.
Yeah, all of those comments I embrace. I just want to note that in the ASIL report that I mentioned at the beginning of this session, there is a section called Situation as a Whole in question marks. And it's a very interesting discussion about the future work of the court, namely whether the prosecutor should be under the kind of pressure that he or she currently is when there's a referral or certainly a proprio motu situation, to assume that the duty is to examine the atrocity crimes of the entire situation by all parties. Now that's kind of a given in the lore of the Rome Statute history, but it's not written down as such. And I think it's a constructive conversation in the ASIL report that one could be a little more realistic about how one approaches a situation and where one is devoting one's resources, investigative skills, and also the gravity of the crimes by various parties. And I sort of felt that Prosecutor Khan's statement on Afghanistan just walked a little bit into that territory, taking both, look, there's a lot going on here, but there's also gravity considerations. And of course, he didn't say this, but just, yes, the United States benefits from the analysis that he has made. But I still think there's some merit in how he reached that analysis.
Can I just add one real quick thing, or Diane, please, Diane?
Thanks. Yeah, a couple of quick points on that. First of all, I want to underscore how important the calls for transparency by my co-panelists are. And I want to underline the importance of the call that Eric Holder made to release some of the documentation behind the Durham investigation into CIA atrocities. And not so much for the reasons the ASIL report talks about, but because we as a country need to deal with this and we haven't fully reckoned with this. That said, I want to use the points that my co-panelists have made to say that I think they illustrate a way in which this moment of opportunity for a reset and a realignment in the way we engage with the court can lead to constructive progress, right? And we're starting in a place where we need to make progress from. As others have said, the prosecutor applying the court's own gravity criteria could reasonably conclude that at this moment in time, in the wake of the Taliban takeover, focusing, prioritizing, and that's what we're talking about. We're talking about prioritizing limited resources to deal with current, ongoing, massive abuses on the part of an entity that hasn't, and we can't reasonably expect to undertake complementarity, is where he needs to concentrate his efforts right now without attributing bad faith to him. And that's really the key point. And this relates to the other point I made earlier about our own rhetoric in the way we scrutinize the prosecutor. There were grounds that I think it's important for us to be aware of and to articulate that we can actually find merit in and not attribute bad faith to for the decision he made. And the last thing I'll say about that is this actually is an area where we have an opportunity for a new consensus that we haven't had for several years. Some of the strongest supporters of the ICC have in recent years called for it to prioritize more effectively than it has, and therefore be better at delivering justice to victims of mass atrocities. And this happens to be an example of the prosecutor doing that. And it incidentally happens to align with US interests, but I don't think we should assume bad faith when he makes a decision like that.
Mike, you wanted to add a point.
Yeah, no, I totally agree. I was going to use the phrase, Diane said it perfectly, but the design of the Rome Statute is a cooperative synergy where states want to work towards accountability, as does the ICC, and where states support to include non-states party, which is what we can do. We have plenty of authority to do that, and we should do it. The language in the ICC jurisprudence is that admissibility is not met when there are sparse and disparate efforts in light of the frequency. And this is where I think Diane, and I said this earlier, but she used the word transparency, which I didn't. That's really what I was describing. I think an awful lot more has been done on the CIA side than is public knowledge in terms of accountability and punishment. And there's a myth out there, and I think in the early phases of the Afghanistan investigation, the court actually helped spawn this myth that purely administrative efforts are insufficient to satisfy complementarity. Standing alone, that might be true, it's debatable. But when you take a full-blown administrative investigation with subpoena powers and millions of hours spent on work, and then you put it in front of a full-blown panel of independent prosecutors who make independent prosecutorial decisions, if that doesn't satisfy admissibility, then nothing on the planet does. I mean, and that's what's happened in our experience and in other experiences in countries. And I just think we need to rebuild this idea of a cooperative synergy without this undertone of distrust. And because I think Clint's exactly right. This conversation immediately leads people to say, oh, it's all just political. Well, remember, we have a vested interest in sustaining and in strengthening accountability efforts across the international system. And always tossing things aside as, oh, that's just power, that's just money, that's just politics, that's just personality, I think undercuts that effort. We need to try to be technicians here and approach these things as rational prosecutors. One last thing, we work in conjunction with the court. The idea that there's, you name me a country of the world that would be totally copacetic with a secret list of officials and that the prosecutor keeps secret from the world and then launches a full-on investigation. That's not a cooperative synergy. There needs to be a, okay, here's who we want to look at. What have you done? How, you know, and where the gaps are. That's what we really need to be working towards.
Well, I do want to move on. I mean, I think there's so much we could have a panel just on this question, but, you know, Diane did say we haven't, I think, really grappled with the torture scandal in America. And, you know, maybe making clear what the US has dealt with would be helpful, as Mike suggested. You know, but, you know, some of it may, I think one of the things to look at is, I believe the investigation, what Durham was asked to investigate was any of the torture that was utilizing techniques over and above what was approved, is that prosecutable? When indeed, I think some of the techniques approved were illegal. So anyway, I hope this all comes to light. I think there are still arguments to be made. This hasn't, you know, really been dealt with, but maybe we'll do a just Afghanistan panel next time. I will go on to my next question, and I will address this to Clint and Diane. Another perpetual sticking point in the US-ICC relationship has been the ICC investigation related to Israel-Palestine, where the court has been looking into crimes on both sides related primarily to the 2014-2015 Israeli incursion into Gaza. What should US policy be related to this, or is this a matter for Israel and Palestine to address? For example, by engaging in complementarity or otherwise. Do you see this investigation, assuming it moves forward, impacting on the US-ICC relationship? Clint, do you want to start us off?
Yeah, I'd be happy to. I guess in an ideal world, this would be a matter for Israel, the Palestinian Authority, and the ICC. But let's be clear, both of the parties have sought to internationalize the issue. I think the US, because of its long-term relationship with Israel and domestic politics, has largely been much more supportive of Israel's position. US support was more explicit during the Trump administration, but the Biden administration, and particularly many members of Congress, have been critical of the ICC investigations in this matter. What I would like to see is the US being more supportive of the ICC's position and less focused on the concerns of the parties. And one way that could be done, as you mentioned, is encouraging genuine efforts at complementarity. The Israelis have shown some willingness to do this in relation to investigations of alleged atrocity crimes. But the real sticking point for the Israelis is any ICC investigation focused on the legality of their occupation of Palestinian territories. Obviously, because Israel doesn't feel that the occupation is criminal, it's impossible to address this issue through complementarity. They don't think there's a crime to investigate, nor certainly one that's worthy of prosecution. So this creates an unbridgeable divide where complementarity is concerned. So far, the US has not challenged this Israeli position, and frankly, I don't see that happening. Instead, the US has really taken the view that any ICC case on Israel-Palestine risks undermining the peace process and predetermining outcomes there. I think that's a questionable proposition because it's hard to see much going on with the peace process right now in any event. And I'm not sure that I would agree that an ICC case would prejudice a final resolution anyway. But as to your final point, I think the ICC investigation in this matter does potentially impact the US relationship with the court, and in some ways, perhaps more significantly than the Afghanistan investigation. The US did make, I think, very real efforts at complementarity relative to Afghanistan, as Mike just talked about. Again, particularly in relation to the allegations concerning US military personnel. But all in all, the US tried, at least until the Trump administration, to address the Afghanistan investigation in a very business-like manner. It was not overly politicized. It was not overly emotional. Where Israel is concerned, though, it's much more politically volatile. Again, because Israel views investigations into its occupation of the West Bank as an existential threat, and is unwilling to engage on that question at all. So for Israel's supporters in Congress, this leaves them very little room to maneuver. They feel like they either have to support Israel wholeheartedly or reject altogether Israel's position. So unlike the investigations in Afghanistan, where the US government had a more nuanced approach and members of Congress weren't forced into taking a hard stand, Israel's more absolutist approach makes that much more difficult. And you also had the issue of Israeli political figures speaking directly to the American public. Then Prime Minister Netanyahu, doing interviews, going on like the Christian Broadcast Network, trying to rally the US public against the ICC and asking them to bring pressure against members of Congress. You didn't see American generals going out and trying to stir up the American population to shut down the investigation on the Department of Defense. So all in all, I mean, this is, again, just a much more politically volatile issue. And what we've seen is some members of Congress who have traditionally been very supportive of the ICC. And even in the conduct of the investigation on Afghanistan, have taken a very different stand where Israel is concerned, have signed on to the AIPAC letter being critical of this, for example. So it's going to be tough, I think, for the administration to navigate this back to more of a middle ground. And as I said, I think in many ways, this presents much more of a challenge for the US relationship with the ICC than does the Afghanistan investigation.
Thank you for that. Diane?
Oh, I agree with everything Clint said. The administration has already expressed its disappointment and opposition to the investigation. Congress is not going to become more quiescent. It's very engaged and has been for a while on this particular investigation. So there's going to be a lot of pressure on the administration. There's several things, though, I think that are really within reach and important things to encourage the administration to do. One is that it has to take a really strong stand on something that it's already begun to address, which is the designation a week ago, I think, of Israel, by Israel, of several Palestinian NGOs as terrorist organizations. One of which played a prominent role, and it's a longstanding, highly respected organization, which took a role in bringing the Israel matter to the prosecutor. We have to be really firm about protecting civil society organizations who are engaged with the ICC. And that's just got to be non-negotiable. It's also important for the United States government to realize and prioritize even more than it has the importance of addressing the illegal settlements as a political matter. It is an issue that I think this administration is concerned about and has addressed, but Israel has to address this in a better way than it has and is now heading toward. And I would love to see this resolved in the place that it most appropriately belongs, which is in the political sphere. That may be that ICC advocates have to work alongside partners who are working on more of a political front, but there are areas of overlap and intersection here. Just a brief example, one trend in recent years has been for US officials and members of Congress in particular to be reluctant to refer to the occupied territories and are increasingly referring to disputed territories. And I think, again, we need to be working in alignment with efforts to address what are war crimes, but we have to address them at a policy level as a priority, because the ICC can't single-handedly manage the question of US settlement policies. And finally, just to underscore a point that the ACIL task force makes often, which is that as we address issues that concern the administration and members of Congress relating to the ICC, and this is the prime example, it's really important for us not to use overheated rhetoric. We saw what happens when we react in a way that is so wildly out of proportion to what might be seen as a national security threat. And so here it's going to be critically important that we play our part in keeping the temperature down as we address this.
Thank you, Diane. Mike, you wanted to briefly weigh in on this?
Oh, yeah, no, I defer to David, and then I'll wrap up.
David?
Oh, just very quickly, I want to just extend what both Clint and Diane spoke to, and Diane actually got into it a little bit. I agree with Clint that, yes, the peace process is a very dormant process right now. It's not something that is on the front burner or extremely active. But I would also take from what Diane said that there is, I think, an importance when the peace process can actually be resumed, if that's possible at all, that there could be a way to diffuse this tension between Israel and Palestine that, of course, is now in the ICC realm by making the ICC situation a matter of negotiation within the peace process. Now, the prosecutor will just have to observe this and use his discretion as to what he sees taking place. But remember, it's always possible for Palestine, if those talks progress in a way that can deal with the complaints raised before the ICC, it's possible for Palestine to essentially withdraw its referral of the situation to the ICC. Now, that's a little unorthodox. We didn't provide for that in the Rome Statute, but nonetheless, still the prosecutor could use his discretion to recognize a withdrawal of the referral if the peace process, in fact, has dealt with some of these issues. And I would simply suggest the peace process, first of all, could deal with what Diane and Mike emphasized, which was transparency. In other words, there would be something within the peace process that would be very transparent about the allegations and about the efforts by both jurisdictions to deal with those allegations. And there could also even be, even in exchange for an Article 98.2 non-surrender agreement between the two parties, there could be a reparations, a system set up. There could be a special chamber set up to deal with cases that arise, even terrorism cases that arise between the two jurisdictions in full transparency. I mean, there's a lot that could go into a peace process to diffuse this. And I kind of find it difficult to see how a peace process could go forward with the ICC situation hanging out there with very active and assertive investigations going on. I think it has to be brought in to the peace process.
Thank you. Mike?
Well, that's a perfect segue, because I wanted to make a related point, but I adopt by reference everything Ambassador Sheffer just said. This is why I loved working for the man. You know, remember that the current, well, one thing I wanted to pick up expressly on Cliff's point that there's a lot of he used the phrase politically volatile. and it's an existential threat to Israel. I also think in a perverse way that's not drawn a lot of public comments. I think this is a real existential threat to the court as well in terms of legitimacy. You know, it's easy to say, yeah, we got to go get them and we got to do this. But remember, long-standing, the specifically stated PA objective was to use Pearl and use that as a backhanded way of getting state recognition and as a backhanded way of elevating their own. They were explicitly political about it, repeatedly, over and over and over again. In light of the Oslo Accords framework, that of course the settlements and borders were to be subject to mutual negotiations. The backdrop to that, and I think Ambassador Sheffer is exactly right. So my point is that both sides have politicized the court in grave ways right now, which you could argue that's what the ICC is inevitably, but we shouldn't allow it to be hijacked explicitly for that purpose by any party or any circumstances. I think it undercuts the independence and the impartiality and the institutional integrity. David's right, one pressure relief valve is Article 53, which at this point, in the interest of justice language, is unreviewable by trial chambers. It's a prosecutorial finding. But the interesting part about that is that current ICC policy, which I wrote about, I think is misguided, is that the interest of justice never includes the interest of peace, right? The interest of justice framework in official ICC policy is only a technical, lawyerly, prosecutorial kind of decision based on the individual, particularized judicial merits of each and every case. I think that's too narrow for a court of this standing. This situation may represent the opportunity to revisit that. And, you know, 100 years from now, when you say that the ICC helped bring peace to that region, that may be the thing we remember as the biggest success of the court, rather than a particular prosecutor or a particular case. Who knows? But I think they have to be extremely conscious of the politically volatile nature of these charges and the real danger that it's corrosive to the very institutional foundations of legitimacy. This is a knife's edge. I think it could go either way for them.
Diane, you wanted to add one more.
Yeah, just briefly, this is for now not relevant because the pretrial chamber already addressed it, but could become relevant in a future case and challenge. This is another area where I think it will be important for supporters of the court to not assume bad faith when reasonable arguments are made. And here, what I'm thinking of in particular are very substantial questions that have been raised about whether the court can exercise jurisdiction based on two arguments, but one of them, just to sort of remind you what I'm referring to, because I think everybody here knows what these issues are, is can a state whose final territory has not yet been determined delegate jurisdiction, particularly when it doesn't currently have jurisdiction over Israeli suspects. I'm not weighing in on that argument, but what I'm saying is it's a serious one. It's a serious legal question, and lots of brilliant scholars have expressed views on this. And this will be an area where I think generally toning down rhetoric and being mindful of how we attribute bad faith is going to be important. Thanks, Jennifer.
Final question. What are some of the positive steps the US could do to help the ICC? And I guess here I'm asking more concrete rather than the overall policy. And not maybe related to Afghanistan or Palestine, but more generally. For instance, the Victim Trust Fund, this is independent of the court. Could the US fund that? Are there other ways the US can concretely assist the court? The recent ACIL report by Beth and Todd excellently suggests that future referrals by the Security Council to the ICC, that the US permit funding, UN funding to go with those. And we have heard already about The ICC does have many budget issues, and that is one of its current constraining factors. So what positive steps can the US do, concrete positive steps? Let me turn first maybe to David.
Yeah, thanks, Jennifer. I'll make this quick. Well, it's obviously self-serving for me to make this first suggestion, but I think there's still merit in making it, which is that I think Secretary of State Blinken should actually deliver just a one-page letter to the Secretary General of the United Nations that withdraws the John Bolton letter of 2002 that was filed with the UN as depository for the Rome Statute, saying that the United States would no longer fulfill the obligations of a signatory state to the treaty. By simply revoking that letter and replacing it with one that we do recognize the United States as a signatory state, not a ratified state, but as a signatory state to the Rome Statute, I think we'd gain a lot internationally by doing so. And quite frankly, it's a matter of our credibility to do so, because the Bolton letter is, I think, remains poisonous on the record. Secondly, as many on the screen before you are also involved with, we've been attempting for more than a decade now to get a Crimes Against Humanity bill adopted as a law in the United States. We do have criminal statutes for genocide, for war crimes, but we don't have a criminal statute for crimes against humanity. This would be extremely important to accomplish. Senator Durbin, chairman of the Judiciary Committee, is the most active individual. He actually filed such a bill in 2010, but it didn't get to a vote. This year, I think, is a very active year in achieving this, and certainly within this two-year Congress for achieving it. And the ACIL report talks about this, this priority. The American Bar Association is extremely active on this. And I'll just leave it at that, getting that done would enable us to exercise complementarity in spades. And frankly, also, it gives us a pathway to the ICC to say, look, if you have questions about any crime against humanity which might fall within a US jurisdictional ambit, we have the capacity in our federal criminal law now to actually take care of it. So please back off, and we'll undertake our investigations and let you know where that comes out. And then I would also, on the funding issue for the Trust Fund for Victims, I would say this is also an issue that I would raise for the International Criminal Court itself and its budget. I've been involved for several years on looking at this issue, and in fact, there will be a rather lengthy report issued by the U.S. Holocaust Memorial Museum soon that addresses this issue, a project supported by the American Bar Association, et cetera, that looks at some innovative ways to finance assistance for victims of atrocity crimes. And also, it's a mechanism that could actually be used to at least cover part of the budget of the International Criminal Court, so that you have some stabilized budget. And then, of course, you blend it with the assessments and voluntary contributions as well. And it looks at the social bond market, which really just took off during the pandemic in an explosive way, and I think established its legitimacy. And I think it's a time to turn the social bond market towards the needs of international justice and of the victims of atrocity crimes, because it has proven its viability now. So that report will be out probably in 2 or 3 months. I'll leave it there, Jennifer.
Thanks, David. Clint, would you like to?
Yeah, sure. First of all, I would echo everything David just said, and I think it would be very important to sort of officially withdraw the Bolton letter. I think that has huge symbolic importance. I also want to refer back to some points that Mike made, I think in response to the first question, if I'm correct, where he's talking about the Dodd Amendment and the American Service Members Protection Act. And this does give the US a lot of flexibility to do things that are supportive of the ICC, things that we have done in the past and I think we could do going forward. Some of these things include expanding the rewards for justice program to provide rewards for information leading to the arrest of fugitives. This was done during the Obama administration. I think it has lapsed a little bit. It certainly was not done under Trump, but it's something that we can reinvigorate. Even going back to the Bush administration, there was sharing of intelligence information to help identify and locate fugitives. There's been information that was provided under Bush and under Obama to help with ongoing investigations. So a lot of the sorts of things that we have done relative to other international criminal tribunals, we should approach the ICC in the same way. And it has been kind of a hit or miss approach. It has varied from administration to administration, certainly varied from the first to the second term under Bush. But I would like to see us get into more of a consistent approach where these things become as routine as they have been with the other tribunals. Another point you brought up was the ACIL report recommendation that the Security Council attach dedicated funding to any referrals of matters from the Security Council to the court. I think that's a great idea. I'm entirely supportive of it, but I think it's easier said than done. There is a lot of tribunal fatigue on the Security Council. It's not just the United States, but the United States, I think, has perhaps particular concerns about this because there's a feeling that the formula for assessed contributions is weighed against the US when other economies have certainly blossomed in the meantime, particularly that of China. So I'm not sure that that's something that's easily overcome. And in many ways, it's really just an academic discussion right now. I mean, as we've seen in recent years, certain permanent 5 members of the Security Council have been very hostile to any referrals to the ICC, whether it's Myanmar, whether it's Syria. And I'm not sure that's a dynamic that's going to change anytime soon. But again, I think it's a great idea. In theory, I just think it's going to be very difficult to put into play in practice.
Diane, did you want to weigh in on this one?
Thanks, Jennifer. I had some technical difficulties that cut me off, so I missed the beginning of this round. So I think I'd better pass, but thank you.
Mike, did you want to weigh in on this one?
Yeah, just 2 quick things. One, I want to pick up on something David said. I think, because he and I have talked about this, that his social bond thing is the wave of the future. And, we've talked a bit about the ACIL report that Beth and people have worked on. There's language in there about the trust fund for victims, which we can facilitate as a non-state party in any event. I think that's the wave of the future. And I think, the human interests here, it's always right to help people under any circumstances, even if they're involved in an ICC case. And I think there needs to be a clear moral imperative on the part of the United States to facilitate that. I think David's approach to this is exactly right and innovative and gives us a whole new way of doing this. The second thing is a little more subtle, but related, because you're talking about the use of money to achieve larger objectives. And this is particularly important in light of Clint's observation that some states have formally blocked investigative efforts and referral efforts, et cetera. The wave of the future here is privatized collection of evidence. We've seen private parties step forward in a number of contexts, and I think each of us been involved in different ways, often on the ground in doing that. I think we need a clear statutory mechanism for the ability to do that in real time that allows evidence to be collected in real time, but also as a statutory matter makes clear that the collector of that evidence has full title to that evidence to use in any way. It's not US government property just because we helped collect evidence of atrocities. And this goes back to something that I said early on. I think this is a core national security interest. So any way we can facilitate real-time collection, think today of Afghanistan, think in the early days of Syria, think about Myanmar today, lots of ways to do this. And I think we need to make funding streams available, swift, unbureaucratic, but also as a statutory matter that the collector has full title to that to use in any way they see fit, whether it's other host countries or immigration cases or ICC evidence. or leading background evidence or whatever else. I think that's just the right thing to do here.
Great, thanks. Unless any panelist wants to weigh in on anything else at this moment, I'll turn to a couple of questions. So we have in the chat the question, what about the Kampala amendments on non-aggression, or its amendment on the crime of aggression? These amendments pose problems for US humanitarian intervention. I think this calls for just clarification of the jurisdictional regime on the crime of aggression. David, do you want to, or should
I'll make an opening remark about it. Yes, the crime of aggression has an intersection with humanitarian intervention that we always have to be extremely careful in recognizing. You don't want a humanitarian intervention to slip over into the realm of illegality as an act of aggression. I do believe, and of course I used this argument, during the Rome negotiations and before, in terms of where the United States was a bit skeptical about the crime of aggression. We wanted it very specifically defined so that it would not imperil the right of humanitarian intervention, which itself has fallen out of favor over the last 20 years, as you know. It's not as if humanitarian intervention is some popularity contest anymore. There's a lot of skepticism and a lot of opposition to it. And that's within the academic community and elsewhere. I still strongly believe in the right of humanitarian intervention, even though the American populace would probably not be very favorably disposed to it in recent years and today. But I don't think the crime of aggression as defined in the Rome Statute now, after the Kampala Amendment, really undermines the ability of states to engage in humanitarian intervention under certain circumstances. It's a long story, but I'm just saying that I don't want people to slip into the thinking that what happened at Kampala wipes out the right of humanitarian intervention. I would argue, no, it does not.
Sorry, I know I'm not a panelist, but just to say there was also negotiated at Kampala an exclusion from jurisdiction for non-state parties regarding the crime of aggression. It has a different jurisdictional regime. So the US is actually completely exempt. You could, decide whether that's good or bad, but it's in 15 bis paragraph 5. So I think we don't reach the question, although I think, David's analysis sounds right. Harold Coe wrote at one point did a presentation that the court was criminalizing humanitarian intervention. I have a piece why the crime of aggression amendment does not criminalize bona fide humanitarian intervention, which then makes it very difficult to try to explain what is bona fide, which is, it's a long discussion and another fascinating topic. I don't know if anyone, Mike or Clint or Diane, wants to weigh in on the aggression question.
Just very quickly, I think what we need to be very careful about, and kind of going back to my response on the last question, is the intractability that we now see in the UN Security Council, and just making sure that the definition of what is an authorized humanitarian intervention is not limited to only those things that are sanctioned by the Security Council. Because I think if we do that, we may see the end of humanitarian interventions altogether.
I think we need a whole other panel on this one. This is a huge question.
All I can say is here to what Clint just said. That's a fascinating subject that a lot of academics have born into, but that's exactly the point.
Yeah, let me add just like 10 seconds.
Yeah.
It's a perfect example to me of the whole topic of this panel. How does the United States work with the ICC? The US delegation in Kampala was a vital glue, the largest delegation, a really important role in helping pull this off in the first place. And I think that's a nice example of the kinds of things we can do that balance everybody's interests, that help equalize the conversation. And in that case, there was one case where American diplomacy was pretty darn effective. You can go back and read the speeches.
Well, Mike, there were also a lot of disappointed NGOs who thought the jurisdictional regime should have been much broader. It was narrowed in Kampala, and then it was further narrowed at the 2017 ASP. So it's
called
quite a
diplomacy.
narrow jurisdictional regime. So for good or for bad, I think there are different sides to that coin. So I'm going to just turn to some of in the Q&A. I'm looking at, I guess, the last one. Given panelists' notes on the impact of rhetoric on the ICC and the need to demonstrate its value to US policy going forward, both from the USG and from civil society, do you have any suggestions on how to break through the exceptionalism which many policymakers treat the ICC? And is there benefit to better articulating the ICC's connection or role in relationship to agendas such as atrocity prevention or women, peace, and security? It's the last question in the Q&A. Would anyone like to try tackling that one?
I think it's a great question. Yeah. I think, as I indicated earlier, that supporters of international justice need to do a broader job of engagement with the public, with Congress. There's a lot of misunderstanding about the court, and I get questions all the time along the lines, has the ICC gone off the rails? And then I explain how it really works or what really happened in a case, and their perception is very different, but there is going to need to be that. But I think a really important point, and it's a lesson that a lot of us who've been in government have learned, is that where there's skepticism about the ICC in general, you're more likely to make progress in concrete cases. And I think it's going to be really very important in the future, as it's been in the past, for us to seize, not just look for, but really seize opportunities where we want to support what the ICC is doing and to make a genuine value-added contribution and talk about it then, and talk about to the American public why we are supporting it and what we see the impact being. Thanks for that question.
Would anyone else like to weigh in on that, or a final thought? We're just about out of time. We have like 2 minutes left. David.
I think I would just add one thing we haven't really spoken to here, but for those of you who are interested in the ICC and its future, don't overlook the independent expert review report, which came out on, I think, September 30th of 2020, as I recall, and is available on the web. This is a very, very detailed examination of reforms that you know, probably should be taken at the ICC, or at least a good number of them. And it's a good template from which to work. And I assume that as the Office of Global Criminal Justice looks at this within the US government, they're kind of looking at the independent expert review as a platform upon which the United States can support very constructive efforts through its rhetoric and otherwise to upgrade the ICC so that it's an organization that the United States really has great pride in having a relationship with.
Well, I think you have the last word because we're basically out of time. It's the independent expert review. I don't have the link right handy. I think you have to Google it. It's about 300 plus recommendations. It's massive, and states are now working their way through in the ASP in a process to try to suggest which ones to prioritize in the short term. But anyway, a big round of virtual applause to the panelists. Thank you so much for joining. Thank you to the audience. Thanks. I think someone just put the IER report in the chat for me. Thank you very much. Goodbye, everybody.